The raging controversy about the 499 students who believe they passed an exam to be admitted to the Ghana School of Law, the only Ghana School of Law, but somehow, or rather, they have not been admitted. The process began. Let's go through the trajectory, the calendar of events that have occurred around this raging and controversial matter. So we title it, The Law School and the 499 Telling the Story. Okay, so this is how it started. On 29th of October 2021, Parliament, why am I starting from 29th again? Okay, this is the starting point. 18th. On 18th October 2021, Parliament, President Akufo-Addo writes to the learned Attorney General, forwarding the contents of a petition by the National Association of Law Students concerning the admissions for the 499 aggrieved law students. So that happens on the 18th of October. That's the first event in the list of things that have happened at the presidency, at the Office of the Attorney General and Minister for Justice, and at the General Legal Council, and in Parliament. Looking at all of these events that have direct or indirect relation with the 499 students and the problem, this is the first major thing that happens on the 18th of October. President Akufo-Addo writes to the Attorney General, forwarding the contents of a petition by the National Association of Law Students concerning the admission for the students. And then the next thing that happens, oh my goodness, the next thing that happens after the 18th is the 26th of October. Okay, the President of the Republic writes to the Attorney General, directing him to make the necessary intervention. So let's go back to 18th October. The President writes to the Attorney General and he forwards the contents of a petition to him to look at. Okay, whilst he forwards the petition, the people at the presidency, the lawyers at the presidency are also looking at it. And so on the 26th of October, the President of the Republic writes to the Attorney General, directing him to make the necessary intervention on behalf of the 499 law students to address the issue. So on 18th, the President forwarded it. Then on the 26th, the President says that, Mr. Attorney General, I have looked at the petition. I think that you can make an intervention. And he says, you can make an intervention pursuant to the Attorney General's power under Section 15 of the Legal Professions Act. That happens on the 26th of October, 2021. Okay, let's move on. On the, sorry, I'm missing the date. Okay. Then on the 29th of October, so 18th October, the President receives the petition forwarded to the Attorney General. On the 26th of October, the President writes to the Attorney General that you can make an intervention. On the 29th of October, Parliament, at a sitting, passes a resolution in the terms, the General Legal Council is hereby directed to proceed and admit all the students who passed in accordance with the advertised rules of the examination. The Attorney General is the leader of the bar in Ghana, and he must see to it that the directive of the 499, he must see to it that the directive that the 499 students who scored 50 marks are admitted and it's complied with. We do not want to get to the contempt of Parliament issue. So on 29th of October, Parliament passes a resolution unknown to Parliament that on the 26th of October, the President had written to the Attorney General, directing the Attorney General that he should intervene in the matter pursuant to the law, really, pursuant to the law. Our problem with Parliament on Tuesday was that in passing this resolution, Parliament was unaware of anything that the Attorney General had been doing. So that's the important part. We are critical of this situation because we know that the Parliament could have invited the Attorney General. When Parliament looked at the situation, they could have invited the Attorney General to say, Mr. Attorney General, come to Parliament. Parliament has the power to do that. They can subpoena a minister by many other means, including by questions and answers, what they call ministerial question time. In fact, today, the Attorney General went to Parliament to answer questions. Whenever Parliament has concerns about anything, they call the Attorney General. We'll show you a video. You see the Attorney General today, this morning, he was in Parliament to answer questions. Nothing to do with the 499. There is the Attorney General on your screen. He was answering questions in Parliament today. So when Parliament is looking for the Attorney General to ask him questions, they know how to get him there. So what happened on the 29th of October was perhaps unwarranted. Perhaps it was unwarranted because Parliament has the power to bring the Attorney General in. So on 29th October, when Parliament were passing a resolution, but they know where the Attorney General, they know how to bring him to Parliament. This morning, they brought him to Parliament. Show the video again. This morning, the Attorney General was in Parliament. He was answering questions, and we'll show you the video later on so you can hear the sound. But they will just put put the video back on and you see the Attorney General. That's him. That's the Attorney General on your screen appearing before Parliament today, the committee of the entire Parliament, as they say, the committee of the whole, to answer questions. He was answering questions. So we are at a loss why on the 29th of October, Parliament will pass a resolution, as it were, to direct the Attorney General to do something. They could have asked him that, Mr. Attorney General, come to Parliament and tell us what you're doing about this matter. So because by the 26th of October, on the 26th of October, 3 clear days before the 29th, the Attorney General had received the President's letter. So if Parliament had called him on the day the resolution was passed on the 29th, instead of passing the resolution, you would have told them that I've received the directions from the President, and the President has pointed me to my power under Section 15 of Act 32 of 1960. So I'm proceeding to work on it, and would have had no problem. That's the better way in which democracy works. That's the authority of Parliament. They can bring people there to explain what they are doing, why they are doing, and why they are not doing something. So we are still quite concerned about the resolution that was passed on the 26th. Okay, nonetheless, on the 1st of October, the Attorney General writes to the General Legal Council. 1st of November, the Attorney General writes to the General Legal Council. So 18th, he receives it. 26th, he gets clear directions from the President pointing him to the law. The 1st of November, he writes to the General Legal Council about what can be done. He gives the General Legal Council some options. All that is happening on the 1st of November. Then 8 clear days later, Parliament, mainly by the minority members, moved to invoke Order 82 of his standing orders to file a motion for a vote of censure. It's not censorship. For a vote of censure against the Attorney General. Okay. So on the 9th of November, Parliament, by its minority members, moved to invoke Order 82 of its standing orders to file a motion of censure, not this one, against the Attorney General. That's what happened on the 9th of November. The point we're making is that if Parliament had perhaps done it differently, we would have seen what is happening. Now, what is the latest then? So the latest is that the Attorney General has written a letter to the General Legal Council. We'll show you the letter, and we'll also tell you that there's a final important meeting of the General Legal Council to assess what could happen. Let's look at what the Attorney General has written to the General Legal Council. Written on the 1st of November, pursuant to the Presidential Directive, pursuant to Section 5.1, is it 1.5 or 5.1? I'll get it, of Act 32 of 1960, which says basically that the Attorney General has power to give the General Legal Council some direction, and the Council shall comply. That's what the law says, that when the Attorney General gives the directions, the Council shall comply. The President refers to the Attorney General, referred this to the Attorney General referred to it in his letter to Parliament. Okay. Dear Sir, he says, I'm in receipt of 2 letters dated 18th October 2021 and 26th October 2021, written by His Excellency the President on the above subject matter. The letters by the President allude to the separate petitions by 499 students, etc. Let's move to the next page. His Excellency the President, upon the examination of the petition, has directed me to exercise my powers under Section 15, it is, of the Legal Profession Act 1960 to make the necessary intervention to the General Legal Council on behalf of the 499 students to address the issues and advise that the students be admitted into the Ghana School of Law. I have examined the petition by the law student, a copy of which was attached to the letter by the President to me, and I make the following observations. Okay, it talks about the notice in the daily graphic of the 50%, that the notice did not state what it is, that the admission process is as follows. He goes through that, what the General Legal Council can do and what the General Legal Council cannot do. And then eventually he says the General Legal Council's notice seemed to have been hinged on Section 13.1, where the section says that the General Legal Council will have the power to admit the number of lawyers and the manner in which to admit it. Now, this is the important point. Section 4, paragraph 4 of the Attorney General's letter, he begins, however. So that is after he has told the whole story about everything that happened. The letter and admission notice was put across. The admission notice did not quite clearly say that the pass mark is 50. The admission notice is also founded in law on the Legal Profession Act about the role of the General Legal Council, what the council can do. He makes all of that position. All of that is really in support of the General Legal Council position. And all of that is by and large against the students. But then he goes on as a lawyer, and this is how he continues. However, in my respectful view, recent developments in legal education, particularly the modus adopted by the General Legal Council for the regulation of examination into the Ghana School of Law, enjoined the General Legal Council to adopt greater transparency and consistency in the process of admission into the Ghana School of Law. That's a very important caveat, very, very important intervention by the Attorney General. It says that in spite of all of what I've said already, looking at the current modern development, when we were in school, we used to learn something called law and development, where it talks about how the law in its old states must be applied in a way that makes it purposeful. Okay, so he says, what has been happening in the world these days? Because of development, the General Legal Counsel should have been more transparent in telling students what is clearly expected of you. So that they should have told students, as we are hearing, that students were expected to get 50% in paper 1 objectives, 50% in paper 2 written. The 50% will come together and then that will form 50% if you pass. What has happened is that some people did 40 in the objectives and 10 here. 40-10 gives them 50. They believe they have passed. General Legal Counsel is saying that no, you haven't passed. And the Attorney General is saying that there should have been greater transparency in the communication to the people who are going to write the exam, the candidates. Okay, let's move on and see what it says. It says, having applied a general pass mark of 50% for the examinations in previous years, irrespective of whether the 50% was obtained in multiple choice or essay, and this standard having generally been understood to be the applicable entrance examinations into the law school, reasonableness and fairness required that the Ghana School of Law, the General Legal Counsel should have communicated the alteration in the process of admission of the students to the Ghana School of Law. So he's saying that over the years, you have been doing 50%, as we say, simpliciter. 50% simpliciter. It's not a complicated 50%. You want to amend it, you have the power to do so. But then you should have communicated to students, because some of these students are taking the exam for the 4th time. That happens all over the world. It doesn't mean anything. The students are taking the exam for the 4th time, some for the 3rd time. So for a student who's taking the exam for the 4th time, in fact, the fact that the General Legal Counsel is aware that there may be students who are taking it for the 2nd, 3rd, and 4th time, and who have taken it within a certain context and under a certain regulation, believing that 50% simpliciter was a pass mark. For such students, you are being unfair to them if you don't tell them that you have truly amended the requirements. You have the power to amend the requirement nonetheless, but you should tell them. That's the point the Attorney General is making to the General Legal Counsel. Very interesting point. Let's move on. He says, this became more imperative when account is taken of the immense public interest in the admission process of the School of Law. Paragraph 5, it is observed that the notice of the 14th of May 2021, published in the Daily Graphic, did not contain any statements as to what the pass mark for the examination was or how the success of candidates will be determined. Respectfully to the General Legal Counsel, he says, I consider this default material. Even though not unlawful for the General Legal Counsel not to have indicated a change in the determination of the pass mark for the entrance examination, the publication of same after the examination created unwarranted doubt about the transparency of the process. So he's saying that the General Legal Counsel has power to do that. But if you didn't tell the students that you have changed the criteria, and then they finish writing the exam, and then now you tell them the criteria is different, he is saying, the Attorney General is saying that one creates doubts about the transparency of the process. Given the wide public interest in this matter, the process ought to have been attached with better transparency. Okay, let's move on. Suggested solutions to the problem from the Attorney. This letter is gone to the General Legal Counsel. I've highlighted the perceptions of the lack of transparency and doubt about the integrity of the admission process into the Ghana School of Law, created by the manner in which the admission process were handled by the General Legal Counsel in 2021, as well as the enormous public interest generated thereby. These circumstances, in my respectful view, warrant a consideration of the decision not to admit 499 candidates. I am aware that the arrangements have been put in place already for commencement of the first-year professional law course by candidates deemed to have passed the entrance examination for the 2021-2022 academic year. In view of this, pursuant to Section 15 of Act 32, I advise the General Legal Counsel as follows. A. Grant deferred admissions to the 499 candidates with effect from May 2022. A special provision can be made for the first-year professional law course by candidates already admitted to run from October 2021 to April 2022. The 499 candidates may undertake the program from May 2022 and ending in November 2022. Arrangements will have to be put in place for the 2 sets of candidates to undertake their pupillage and to be called to the bar at the common date in the next 2 years. Or B, grant admission to the entire 499 candidates with effect from November 2021 and provision made for the organization of classes in a way as to be able to cater for the needs of the entire candidates of the Part 1 course of the professional law program. C, organize a special examination in November 2021 to accord to the 499 candidates an opportunity to justify admissions into law school for the 2021-2022 academic year. Such examinations may be on essay questions which properly assesses the ability of the candidates to reason legally and resolve practical problems. I further advise that in the notice inviting applicants to register for the entrance examination academic year, the basis for the determination of successful candidates be clearly spelled out in order to avoid a recurrence of the situation experienced this year. Respectfully submitted by the learned Attorney General. So that's where the matter is. Now, if you look at the trajectory of this event, you see that a lot of work and a lot of thinking has gone on between the Office of the President and the Office of the Minister of Justice. And Parliament is on the side. You can see clearly that if indeed Parliament had actually called the Attorney General, written to him, as they have written to him on other occasions, as they invited him this morning, if Parliament had done that, they would have had a better situation and they would have been better informed. They would not have had the censure, the resolution, and all of those matters that are bringing quarrel within the context of our democracy. So this is where we are. We can now tell you that on Monday, there would be a General Legal Council meeting that will eventually determine the resolution of the matter. There have been actually two important General Legal Council meetings that have happened in this week, actually. This week has seen two very important General Legal Council meetings. We understand that there would be another one on Monday or Tuesday. I'm not sure when. Monday or Tuesday, there will be a General Legal Council meeting. By the time we come on air on Tuesday night, hopefully we will know what the outcome is. So that's for those of you students of the 499, your friends and relatives who are interested in the story. This is where we are on the matter.